technique. Obviously, the addresses since the memorandum was circulated have been able to address that. I understand the addresses this afternoon will perform that same task. We will do it in a reply, but for those interveners who had completed their addresses before they had that memorandum, if in any such case it's considered that neither their written submissions nor their address sufficiently indicate their position in answer to those questions, could we propose that, certainly before I reply, that everyone in that position have the opportunity either to put in, and I'll make an arbitrary suggestion, a 3-page note, or have 5 minutes on their feet?
But when do you...
Oh, I'm sorry, after the amicus has addressed.
But you mean today?
I'm not sure whether it would be today.
Yes.
Sorry.
It would only mean today if my raising it now gives sufficient notice,
Okay.
to be fair. Otherwise, it would be first thing tomorrow morning.
Okay.
Thank you.
Possibly you could cover it in when you reply.
I will do that job for us.
You
in
can
our
start
reply.
with that and then reply.
No, I will incorporate it into my reply.
Into your reply.
And it'll be a reply because I will have heard everybody else on that point.
Well, then,
Thank you.
Maybe say we restrict people to 10 minutes, because we don't want to start wondering like some of them were doing.
I was suggesting some may think that they've already written and said sufficient on the point, and I would not discourage anyone from from that view. Others might think it could be efficiently done, as so often happens, by a short note, conventionally 3 pages. Others may think they'd prefer a spoken address, and I again arbitrarily suggested 5 minutes. But these are suggestions we make in order, as efficiently as possible and with good order, to bring the hearing to an end tomorrow morning, as I apprehend.
we are actually thinking of giving you a day, say tomorrow, if we finish the submission today from the two,
Yes.
for you to brush up
I won't need a day. No,
on your reply
no I won't. I will be able to. I will be able to go straight to reply
tomorrow.
tomorrow.
Oh, thank you. That's good.
Ready.
So we'll just let them know. Okay, so you will just cover it in your reply.
Yes.
Right. Thank you. Yes. Yes.
I believe what my learned friend was alluding to, my lord, is those of us who had presented without the questions that has just been handed to us before tea, if we could be given time to respond to those specific 3 questions. And I believe Justice Mataitonga was suggesting 10 minutes per party that hadn't had an opportunity, because now the Fiji Law Society and the amicus, they're going to have an opportunity to address those 3 points. But for us, those of us who had not had the opportunity to read the questions, if we could be given early tomorrow before the reply by the state.
Yeah, would you expect you to cover it in your closing, in your reply submission?
Oh, my lord, so we are going to respond
Yeah. All of you, after,
after the amicus
that's correct.
tomorrow morning.
Well, the state wants to start tomorrow. So the opportunity is for you to reply.
May I say, Chief Justice, it had never occurred to us that there will be full-scale replies from every entity that has addressed the court. We are the moving party.
Yes,
We are the party seeking an opinion and proposing
right.
an answer. There should be just one reply. to what everybody else has already written and said. There have been written replies after all.
Okay.
So, no, may I say, we would strongly urge the court against the idea of open slather replies on everything by everybody who's already spoken. Rather, one reply from us to everyone, because I'm the moving party, and then, in answer to the 3 questions raised at the morning break, those who had already finished their address
Right.
should have the supplementary opportunity I've proposed. Either 3 pages or 5 minutes or 10 minutes, whatever the court decides, but limited to that issue, of course.
Okay.
So, Mr. Walker, it's anybody who wants to say anything about the questions
That's it.
says it first,
Yes,
and then you say.
yes, so that I
You
just
do
do it
your
once,
reply and that.
do it as efficiently as possible and finish the hearing off with the reply.
Okay. We'll go along with your suggestions. Right, thank you. The Fiji Law Society.
Yes, my lords and lady, the Constitution has provided the framework for the rule of law in Fiji since it came into effect on the 7th of September 2013, the day after it was promulgated. It is the supreme law of Fiji. Pursuant to that Constitution, the Executive has been authorised to administer the laws of Parliament and has done so. Within that framework, this court has been provided with jurisdiction to hear and determine cases about the interpretation of the Constitution, which it has faithfully done in cases. The common law provides the tools. The Fiji Constitution is designed to enable change. Chapter 11 sets out the circumstances in which it can be amended. Chapter 11 does not in form or substance prevent the Constitution from being changed. The Constitution, as it presently stands, expressly provides for it to be amended by a vote of the representatives of the people, and importantly, the people whose rights are governed by the Constitution. We accept that it may be difficult to amend the Constitution, but it is not impossible. The reason why the provisions are such as they are is to protect the higher law, and that has always been reflected in Fijian constitutions. Your Lordship, the President of the Court of Appeal, raised quite correctly that in previous iterations of the Constitution, there had been the requirement for a 2/3 vote rather than what presently exists of 75%. And Your Honour, the President was also correct to observe that there is nothing that enables the court directly to discern from the framers of the Constitution as to why the 75% figure was chosen. That is an accepted fact. But the issue, of course, is it is not the reasoning behind why 75% was chosen, but rather whether it is a valid provision of the Constitution.
Do you not, I mean, a possible starting point for this inquiry is the way in which the Constitution was promulgated. Most constitutions have some sort of democratic,
Sure.
I suppose, birth story, origin story.
Some do. I mean, the Australian Constitution, of course, didn't. It was put together by a select group of individuals. By a select group. My other friend, Mr. Walker, says to the contrary.
A few of them would have been elected.
Yeah, but to answer Your Honour's question directly, Your Honour, if I may, it is absolutely relevant to consider when we're dealing with the question of efficacy how this Constitution came into about and why it exists. But when it comes to construing the Constitution...
But why can't efficacy extend to the not just to the whole, but also to the parts?
No, the Constitution either exists as a whole, Your Honour, or it doesn't. And this is the reason why this court will be led into error in respect to the approach that is being urged upon it by my learned friend. There is no authority that he has been able to take you to that supports his contention. We are expected if I may just finish, Your Honour.
Well, just put, there's no
Sure.
authority the other way.
Israel, yeah, that's true.
There's no authority at all.
Correct. And what I'm saying, Your Honour, is the court's being invited to suspend disbelief while the state argues that the Constitution is supreme, but also it isn't at the same time. And I'll make good that proposition, because this court has to be very careful of what it's being invited to do. The submissions of the state and some of the interveners invite this court to, in effect, amend the Constitution and remove the requirement for approval from the people and place it only in the hands of members of Parliament based on a simple majority of vote in Parliament. Now, with respect, our submission is that accepting that invitation would be a perversion of judicial power. Courts interpret constitutions, but as a number of Your Honours have reminded our friends during the course of the hearing, you do not rewrite them. That is not your role. Accepting that invitation draws this court into a controversy which is not within its jurisdiction. That is not the role of this court. Now, my learned friend, of course, for the state, Mr. Walker, was questioned by both Justice Arnold and Justice Young as to whether the effect of the state submissions was that this court should determine that the 2013 Constitution could be amended by a simple majority of Parliament, and if that was so, it would reduce the Constitution to being able to be amended like any other legislative instrument enacted by the Parliament. There's some good exchanges at pages 20 and 21 of the transcript of yesterday, although it does incorrectly refer to Mr. Walker as Dr. Walker. He's been called a great many things, but not Dr. Walker. Now, with respect, rather than answer that question directly, senior counsel for the state skillfully pivoted to informing the court on instructions that if the state was successful in persuading the court that the amendment provisions in Chapter 11 ought be declared invalid, and the court concluded that in order for the 2013 Constitution to be amended, it only required a simple majority vote in Parliament, the government would nonetheless persist with putting before the Parliament the 2025 bill, which had been the subject of a first and second reading and received less than the required 75% vote. And I'll come back to that on the impossibility argument. Mr. Walker, of course, advanced that submission to this court on instructions. There are two observations to make about that submission. First, it is to be noted that when the matter was last before Parliament, it had only reached a second reading speech stage pursuant to section 160, subsection 2. It had not yet been referred to a committee for a report, nor, of course, had it gone to the third reading speech. In the event the government puts the very same bill before the Parliament, there is no guarantee and there is no evidence at all that the bill in its present form would get through the Parliament in an unchanged manner. Now, the court's being asked to accept the contentions of the state as to how it should construe the amendment provisions, we say rewrite them, based on an indication, and it's completely irrelevant from the government, that it would put a bill before the Parliament requiring a two-third majority vote. Now, my friend on behalf of the state cannot commit the members of Parliament to take the position that they would pursue the two-thirds bill, the 2025 bill in its present form. And all that is going to happen is that by accepting the invitation of the state, and we say to err, the Constitution loses its supremacy. The court cannot determine matters of construction and application based on a promise from the bar table.
Sorry?
Based on a promise from the bar table as to what the court would do, because my friend sought to use that to assuage Your Honour's concerns, Justice Young's concern, when you put it to him directly. Now, second, and this is important to the questions that were asked by the court in the memorandum delivered today, there are no tools of construction available to the court that can convert the submissions of the state into relief that it seeks. That is quite important. Our learned friends, in effect, invite you to pick up the blue pencil and to insert words into the Constitution.
Well, a blue pencil normally removes them.
Well, but they're asking you to go one step further. Your Honour's right, in restraints of trade cases and commercial contract cases. But in the case of a constitution, what my learned friend is asking the court to do is to excise from it the people. So in order to enhance democracy, we are going to minimise democracy by taking the people out of the vote. And then secondly, what my learned friend is inviting you to do is to reduce it to 2/3. Now, one has got to take a step back and ask the question, what are we doing here in a court of law grappling with such submissions? They are inherently nonsensical. And this court's being invited to go into an area that is political, not judicial. You are being asked, in effect, to trump the views of the people of Fiji and express your views.
What
Yes.
views of the people?
Well, the views of the people that would come from a referendum, Your Honour, in respect of what is set out in section 160.
Yes, but
Your-
not the views of the views of the people who, as it were, supported.
No, of course not, Your Honour.
No.
But Your Honour, that's accepted, and I'll deal with that front on when I deal with the 5 topics in my oral argument. But nobody is shying away from the stated fact that the 2013 Constitution and the circumstances which it came to being were less than ideal. They were not ideal. Nobody is shying away from the fact that some of the provisions can be improved and made better. Of course they can. But that is why one has either a committee stage to debate these things in the Parliament and bring into that consideration the views from the outside, or, as the Human Rights Commissioner said, to have some form of a constitutional convention. But Your Honour, I know, was being flippant when you said it, that when Your Honour said, well, that's why they've brought it here. Well, no, that's not why they've brought it here. Your Honour's views are Your Honour's views as to what should be the Constitution of Fiji, but that's not your role. That is the role of the people. And we have to be very careful to take a step back and understand one can be critical of the 2013 Constitution, how it came into effect, but once you accept that the doctrine of efficacy makes that the supreme law, then there comes a point where the court's jurisdiction is limited as to what it can and cannot do. And I want to come back to deal with...
Can I just stop you there? Let me
Yes, my
Let
Lordship.
me discuss the issue of efficacy with you.
Yes, my
And
Lordship.
see whether we share the same view. If we were to take away the 3 elections that were held under the 23, would you still be grounding your argument on efficacy?
So, Your Honour, if there hadn't been acquiescence in respect of the 3 elections
Yes.
that have been held, I think that would take away one of the powerful indicators in respect of the efficacy principles that come from Prasad that both Justice Arnold and Justice Young have referred to. But we can't ignore, of course, that there have been 3 elections.
Okay. What if the first 2 were held in circumstances that were basically controlled? How does that affect the issue of efficacy?
Well, I think to answer, Your Honour's asking me a hypothetical question because...
May not be.
No, I understand, Your Honour, but the problem that we have, of course, Your Honour, is, and I've read the article that Justice Young referred us to of the Honourable Dyson Hayden, in respect of constitutional facts. But that scenario Your Honour has put up, as you may be putting it to me as a proposition, that forms no part of the constitutional facts that you have before you, nor is it part of any material. And the point to be made about the Hayden proposition that Your Honour Justice Young was referring to, he was saying that in respect of the determination of constitutional facts, you may not need to adjudicate and make findings based on evidence before you, but you need to have some material that you have before you. And we get that from the authorities in part that he's referred to. But again, we have to be careful about accepting propositions from the bar table and so then transforming them as a tool or the basis to, in essence, rewrite a constitution. And that is a problem. What we have met with, and Counsel for the State made a number of concessions at the outset. One of them was that there had been 3 elections under which, of course, governments had been elected in respect of this constitution, under which members of this court, of course, have served. And we cannot obliterate or ignore history in terms of what has occurred. And I think, as I said, there is a lot of things that have been said in this courtroom by some very experienced leaders of the Fijian profession who, on instructions, have put some very important propositions as to troubling features of the circumstances in which the 2013 election came into effect. But none of those matters that are raised touch on the question of efficacy. all of them may have some very good views about how this constitution can be made better, because every constitution can be made better. But this is not the forum to do it. And all that is doing is undermining the authority of this court by inviting it to do something that it doesn't have the power to do, drawing it into a controversy where, in effect, it becomes a shield. And that is not the role of this court. This court has always been the protector of the rule of law in this country and has always been the protector
and the
of the
rule of
rights.
efficacy to which you require.
I'm sorry, I apologise, Justice French.
That's right. The rule of law, the rule of efficacy to which you refer are to be found, are they not, in the common law of Fiji,
They are, Your Honour, and I'll come to that.
which we apply and develop in response to the circumstances of Fiji?
Yes, Your Honour. I accept that, without question, Your Honour.
Yep.
And Your Honours, I just wanted to touch upon a number of other matters before I turn to the outline of my oral argument and go through the 5 issues that we've identified there. There is another issue which has been touched on eloquently by a number of advocates, in this case, a number of counsel, and that is, if we are looking at the doctrine of necessity, because when pressed about the common law tool, you had at your disposal to amend the Constitution, learned counsel for the state referred in passing to the doctrine of necessity by reliance on the Cyprus case, and I'll come to that, as somehow providing the hook upon which this court could provide the radical relief that he seeks. Now, the problem with that is, what is here the necessity? What is the emergency? And I want to come now to the vote. There's only been one vote on this bill, and they lost by 1 vote. How can it be said that it is impossible to get the bill through Parliament? I mean, again, we've got to take a step back and to pick up on Justice French's observation, look at the circumstances here. What you can't find in any realm of acting in good faith and acting with all seriousness that that's impossible. No evidence at all about, are they going to try again? Are they going to go potentially to the next election with a mandate offering to the electorate to say this is what we propose to do, so that when we come back we're going to do this and somehow increase their numbers? These are all things that haven't been explored or done, and this is very premature, this step that's been taken. It is too early to say that it is impossible. And your point, Justice Young, and I suppose it may be a New Zealand phrase about suck it and see in respect of the 75%.
It might have been an Australian one too.
Well, it could be. I mean, I'll shy away from the rankings at the moment. You are number 1. But in relation to the issue of the question that brings us here, and that is that what do we see in terms of the impossibility of 75% at a referendum? We don't accept that there is a basis upon which the court can say that it would be impossible to get 75% of the vote of the registered voters. There is no material upon which the court can conclude that. In fact, at the 2014 election, there was over an 80% turnout. There's the material in the court book that sets that out. So I think one cannot assume that. And again, I don't want to be coming here lecturing based on Australian experiences, but we've had 4 referendums in which there's been, in effect, 75% plus vote in favour of changes to the Constitution. So I just think one has to be careful not to make assumptions which are wrong or have a misguided view in order to trip over oneself to get to where the state wants to be in this matter. And we wouldn't do it anywhere else, with all due respect. These are not submissions that would hold water in another common law country. And we need to be careful that the law is applied faithfully based on material, not for convenience or pragmatism. That's not what we do with constitutions. And can I come then to another point, which is, if I can call it the bad motive proposition. I've given you 2 documents, and I'm not going to detain you on the document about referendum laws for the Fiji Law Society, the addendum. It was said by counsel, very entertainingly for the National Federation Party, that somehow, because there weren't current laws in place prescribing the manner for conducting a referendum, in essence, it was never the intention to hold referendums under the framers of the Constitution. That, with respect, whilst it was an entertaining submission, is just wrong. We know from other countries, New Zealand has the experience, so does Australia. When a constitution comes in place, there isn't machinery there for referendums. It happens when referendums are put to the people. Now, New Zealand has the ad hoc system. We've dealt with that in the written outline. I'm not going to bore Your Honours from New Zealand with that. And in Australia, of course, our provisions came into effect in 1906 when we were dealing with a referendum. So that submission goes nowhere. And really, for there to be suggestions of somehow bad motive attached as somehow the referendum provisions are colourable or a disguise for an unamendable constitution, you've got nothing in order to deal with that proposition. And with respect, that type of submission shouldn't be put because it unnecessarily inflames matters when we've got to deal with what is material facts and the faithful application of the law. Now, Your Honours, can I turn, if I may, to then my outline, and I will try and stick to the outline during the course of the oral argument. And can I go first with the question, Your Honours, of jurisdiction, which Your Honours will see in the outline is the first issue. My Lords and my Lady invited the parties to address the question in the memorandum that was issued on the 14th of August. In determining whether it has jurisdiction under the 2013 Constitution, can the Court determine whether it is legally effective by applying recognition criteria which may be found or developed from the common law of Fiji? Now, this is our submission, but I do note that Justice French has observed there is a different way or a different order to deal with it. And to be quite frank, it doesn't bother our argument as to which way the Court answers it. But we deal first with the substance of question E. And what we say is, our first proposition, is that the first duty of any court is to be satisfied of its own jurisdiction. The Cabinet has invoked, quite properly, may I say, because they've come here to get an opinion from this court, which is what a government does in applying the rule of law. It comes to a court with jurisdiction. They've invoked section 91, subsection 5, and section 98, subsection 3C of the Constitution as the basis for bringing this reference, and has made one of the 5 questions about the validity and applicability of the 1997 Constitution. Nobody in this courtroom makes an objection to the power of the Cabinet to bring the reference. We're all at one on that. Everybody accepts it. That power is found, of course, only in the 2013 Constitution. The 1997 Constitution did not empower Cabinet to make references to the Supreme Court. As Your Honours would be aware, section 123 of that Constitution empowered the President, on the advice of Cabinet, to refer to the Court for any opinion on any question as to the effect of a provision of this Constitution that has arisen or appears likely to arise. The only contest is by the Fiji Law Society and, to an extent, by the amicus on the structure of the power of this court to answer question E. Both the Fiji Law Society and the amicus, like every other intervener, accepts, as I've said, that the reference can be brought. Now, the preliminary question on jurisdiction is whether section 91 subsection 5 and section 98 subsection 3C empower this court to give an opinion on the questions in the amended reference. It is only if Your Honours find there is jurisdiction to opine on the issues in question E that it then turns to whether the 2013 Constitution is legally effective by applying the recognition criteria from the common law of Fiji. But as I've said, Your Honour, Justice French, I accept that Your Honour may seek to invert that in order to satisfy yourself of the jurisdiction. We accept that questions A to D present issues about the proper interpretation and application of the impugned provisions in the 2013 Constitution. So, Your Honours, I have 3 reasons why you don't have jurisdiction to deal with question E. The first is because the provision invoked by the Cabinet to bring this reference to the court is limited in subject matter. Section 91, subsection 5, if I can invite Your Honours to go to it, expressly states that it must be on any matter concerning the interpretation or application of this Constitution. That is a point that Your Honour the Chief Justice and the President of the Court of Appeal have raised on numerous occasions, either during the course of this hearing or in earlier interlocutory hearings in respect of this matter. The reference to this Constitution is used throughout the 2013 Constitution, including in the preamble and Section 2 to refer to the 2013 Constitution. Interpretation or application is a well understood phrase.
Can I just interrupt?
Yes, Justice Young.
Everyone, I think, or virtually everyone agrees that the 2013 Constitution can't be brushed aside. It's there, it's occupying the ground. Is it not a matter affecting the application of that Constitution if the law requires it to, as it were, give way eventually to the 1997 Constitution? Doesn't that necessarily involve a question of application?
Well, it does. That's the proposition that Justice French has been raising with the parties, and that is, do we first turn to look to the 2013 Constitution in order to determine its validity, in order for us to be satisfied as to whether we have jurisdiction?
But they're not all or nothing questions. I mean, obviously it has, no one could say it doesn't have validity.
Well, some have said, Your Honour, with respect.
Well, I think they all accept that it has to be complied with in the meantime, but the invitation is to this court to put in train a set of events that would resuscitate the 1997 Constitution and its institutions.
Yeah, but the starting proposition is that some of the parties take, Your Honour, is that the 2013 Constitution should be the subject of a declaration by this court that it's invalid.
Yes, I know,
that is put quite forcefully.
but when they actually get into the detail of it, they can't really take that very far.
No, I understand that, Your Honour, but out of respect for my colleagues who've put those contentions on behalf of some of the parties, that's a matter, of course, that needs to be grappled with, which is no doubt why Justice French has raised the proposition as to how one deals with the jurisdiction point. Can I just deal with this?
Mr. Moses, just before you go on,
Yes.
on this.
Yes, Your Honour.
It might be said, for example, on the approach which I've been exploring,
Yes, Your Honour.
that one doesn't answer the question about the validity of the 1997 Constitution as an answer to the reference, but rather as an answer to the preliminary question, do we have jurisdiction?
Yes.
And that might, for example, be the subject of a declaration in the exercise of that preliminary common law jurisdiction.
Yes, I accept that, Your Honour. Your Honour, as I said, there were three reasons as to why the court didn't have jurisdiction. The second reason is because this court, as presently constituted, owes its existence and jurisdiction to sections 97 to 99 of the 2013 Constitution. The judges of this court have each taken an oath or affirmation in the terms set out in the schedule of the 2013 Constitution. I don't need to take you to it, but Your Honours, of course, some of you have taken it recently, pages 116 to 118 of our fold of authorities at tab 1.2. That's required, of course, by section 109 of this Constitution. The 2013 Constitution, of course, is the only one of the four constitutions to be cited as the Constitution of the Republic of Fiji, which is in section 162, subsection 1. So the oaths and the affirmations taken by each of you can only be understood by reference to the 2013 Constitution. The significance of this is twofold. The first is that under section 2, subsection 3 to 4, and section 97, subsection 2, there is, respectfully we say, a duty that is imposed on Your Honours, of course, that this Constitution shall be upheld and respected by all Fijians in the state, including all persons holding public office. It's quite important. That can't be brushed to one side. There is a positive obligation on this court to give effect to the Constitution. We say the second is that the court is prevented from looking behind the Constitution that creates its own jurisdiction. Otherwise, you are untethered to any legal basis upon which you are operating as a court. That is quite an important observation that hasn't been grappled with with all due respect, by counsel for the state. Now, the third reason is the ouster clause in section 173, subsection 4 to 5, and section 174, subsection 3. Can I ask that Your Honours go to just section 173, subsection 4 of the Constitution? This is our third reason, which is the ouster clauses. That provision, thank you, that provision makes clear, Your Honours, that no court, whether established or continued by the 2013 Constitution, has jurisdiction to accept, hear, determine, or in any other way entertain or to grant any order, relief or remedy. The words hear and determine are significant because those are the very same words in section 98, subsection 3C, conferring original jurisdiction of this court to hear and determine constitutional questions from cabinet references. And it goes on to say, in any proceeding of any nature whatsoever which seeks or purports to challenge or question the validity or legality, the constitutionality of any promulgation, decree or declaration made or purportedly made between the 5th of December 2006 and the first sitting of the Parliament under the 2013 Constitution. What we say is that the language is broad enough to include the decrees that abrogated the 1997 Constitution and promulgated the 2013 Constitution. What some of the parties do, and this is the People's Alliance Party as an example, is urge this court to entertain and determine a challenge to the validity, legality or constitutionality of the very decrees and decisions covered by the ouster clauses. And that...
But just pause there.
Of course.
Yeah, there may be a conflict between that provision
Sure.
and indeed the Section 73 provisions and Sections 91 and 98.
Well, we'd like to hear the argument, Your Honour. It hasn't been yet tested.
So that, I mean, those sections provide, without apparent limitation, for questions concerning the application and interpretation of the Constitution to be asked and answered.
Sure, but then you have a specific provision.
Well, I know. So we had a bit of an argument about that the other day. But whether the general, which is the more specific provision? Is it the one that confers a particular jurisdiction
It's the
on
one
this
that
court?
it's the one that limits the jurisdiction, Your Honour. That's the specific. That's the guide. Otherwise, you're in effect ignoring the express words of the Constitution. So,
But then you are limited. Look, it's probably just goes round in a circle. But there are, on the face of it,
well, there have been a few. There have been a few circular arguments. Yes, thank you.
Sorry.
Because I mean, it's important to note in subsection 4 it says, notwithstanding anything contained in this Constitution. So one's got to faithfully go back to the words, Your Honour.
Right.
I mean, as I said, we just have to be careful to read the words that come from the Constitution and the cases which nobody has really taken the court to assist the court. I mean, we're not here to give speeches. We're here to assist the court as lawyers as to the very important questions that are being brought to bear on you. You don't have an easy task, given some of the submissions that have been made in this court. But faithfully, we look to the words of the Constitution. Your Honours, can I go to the second issue?
No, before you do that, can you Section 98, 3C,
Yes.
the reference to regional jurisdiction in this context is not tied up to the ones that you referred to under 73.4.
No, they are, Your Honour, because they make very clear that notwithstanding anything else in the Constitution, these are the limitations, Your Honour. So it does, with respect, directly deal with that issue, with respect, Your Honour.
The word original jurisdiction.
Your Honour, his guide has to be guided by the provision I've just taken you to.
No. I've read the provision.
Yes.
Does the word original jurisdiction in the context here refers to all types of legislative provision within the 2013? Or is it this original jurisdiction refers to maybe something that you can derive from common law?
Your Honour, with all due respect, the provision that I've taken the court to limits the jurisdiction of the court to deal with that subject matter. And that provision that Your Honours refer to doesn't in any way undermine or undercut the provision that limits the jurisdiction of this court. Because it's expressed, Your Honour, says notwithstanding anything else in the provisions of this Constitution, it cannot do this. So the court, of course, has to act within the limits of its powers to act lawfully, because the court must act within the limits of its power to act lawfully.
Those are the powers that were given to us, specifically for Supreme Court.
Yes. Yeah. There is no common law jurisdiction for you to give an advisory opinion, Your Honour, with respect, because you are a judicial officer. It either comes from the Constitution or it doesn't. Because the moment you give advisory opinions, you're not a court, unless it's underpinned by the jurisdiction you have. You've got to have jurisdiction to give the advisory opinion. There is no common law jurisdiction for a court to give an advisory opinion. That's our proposition.
A very interesting one.
Yeah, it is interesting, Your Honour, it is. The second issue, Your Honour, in the oral argument document is the legitimacy and legal effect of the 2013 Constitution. Now, if this court, of course, determines that this must be considered by it, I now turn to whether the 2013 Constitution is legally effective. There are two tests applied by the common law, the doctrine of necessity and the test of efficacy. They are separate and distinct, and the authorities from political crises in Uganda, Pakistan, Southern Rhodesia, the Seychelles and Grenada, and amongst other countries, were carefully reviewed by the 5-member Court of Appeal in Prasad. Can I invite the court to take up the decision in Prasad, which is in our folder of authorities at tab 2.8, because I think it bears going to, if I may. Do Your Honours have our folder of authorities? I'm going to keep going. I'm told it's behind tab 2 of the, thank you, Mr Walker has told me it's behind tab 2 of the state's authorities as well. Do Your Honours have that? Prasad? Yes. Can I ask that Your Honours go to page 27, and it's the last paragraph on that page. And if Your Honours, I apologise for reading this, but the doctrine of necessity enables those in de facto control, such as the military, to respond to and deal with a sudden and stark crisis in circumstances which had not been provided for in the written constitution, or where the emergency powers machine in that constitution was inadequate for the occasion. The extra constitutional action authorised by that doctrine is essentially of a temporary character, and it ceases to apply once the crisis has passed. And then can I ask that Your Honours go to page 30 at the top of the page, where the court rejects that necessity is the only test. And it goes on to state that we cannot uphold the submission to the effect that there was no need to look beyond the invalidity of the commander's purported abrogation of the Constitution based on necessity. We must now go on to consider whether this attempted change in the legal order was successful. And very usefully, Your Honours, and nobody has suggested to you, I think, that this decision is wrong or doesn't form part of the common law in Fiji. At pages 41 to 43, the court very usefully there sets out in A through to I the principles for the test of efficacy in the common law of Fiji to determine the issue. Now, for the test of efficacy, I want to make a number of submissions about the relevant principles. First, it follows from the critical distinction between the two tests that the issue in the test of efficacy is not one about the merits or the necessity about the new legal order. It's got nothing to do with it. And some of the comments that have been made here go to the merits. That's not relevant. The issue is whether the new legal order is firmly in control of the country with the agreement, tacit or express, of the population as a whole, and that the overthrow of the original constitution must be successful in the sense that the new de facto government is established administratively and there is no rival government. That's point C of Prasad at page 41. That's the conclusion to be reached from the facts here. In fact, counsel for the state made that concession when he presented his oral argument. Now, can I also just touch upon this? And Your Honour, Justice Young, I think it was, referred to Mitchell and DPP, and that is in our bundle of authorities at tab 2.4, I don't want you to go to it, but I'm just going to just ask you to note pages 71 to 72 of Mitchell and DPP, where in that case it was observed the revolution was successful in that the government was firmly established administratively, there being no other rival. Its rule was effective in that the people by and large were behaving in conformity with and obeying its mandates. Such conformity and obedience was due to popular acceptance and support and was not mere tacit submission to coercion or fear of force, and it must not appear the regime was oppressive and undemocratic. Now, there is no exhaustive list of relevant factors, but the authorities do reveal a number of important matters. The first, I think both Justice Arnold and Justice Young have raised this, is elections, which is dealt with at page 42 of Prasad at H. Elections are powerful evidence of efficacy. Now, the second is the existence of a rival government. The third is the overthrow of the constitution must be successful in the sense the de facto government is established administratively, there's no rival government. And next, whether a rival government exists, the inquiry is not limited to a rival wishing to eliminate the de facto government by force of arms. It is relevant in this case if the elected government is willing to resume power should the constitution be affirmed. Now, those principles, of course, and what we get from those principles is that you cannot ignore what has occurred since 2013 in this country. There have been a number of elections which have had high voter turnout, which have, of course, elected successive parliaments. We've had numerous members of the judiciary appointed. We've had firm administrative control of the government. A fourth point, of course, if I can touch upon, is the reaction of the international community, which is relevant when you're looking at matters to do with the efficacy proposition. At Prasad, I won't take you to it, page 38, it was observed that when comparing the coup, of course, in Fiji with what had occurred in Lesotho, that international approval had attended the overthrow of the 16-year rule of Chief Jonathan by the 1986 coup. On the evidence, the same could not be said of the reaction to the international community to the purported overthrow of the 1997 constitution. That was a matter that the Honours observed. The mere presence of unfairness or the perception of rewarding a usurper in the creation of a new legal order, of course, is not relevant. Can I ask Your Honours go to Prasad at page 24, which is the second paragraph. It's the second sentence on that page 24. First, it's going to a court, it can say that the usurping government, by abrogating the constitution or by changing it in an illegitimate matter, has succeeded in changing permanently the previous legal order and that the new order is legally valid. There is always the danger that such a finding is seen as giving the stamp of legitimacy to a usurper. As against that perception, a court cannot be blind to reality, however unfair or unfortunate that reality may be. And at page 43, I just want to remind Your Honours, I know Your Honours know this, but at the top of page 43, it emphasises that efficacy is to be assessed at the time of the hearing by the court making the decision. That's our relevant time and what we tether the consideration of these matters to. And as I said, quite a lot of legitimate historical grievances concerning the 2013 Constitution, how it came into effect. They're well made and well felt by the people who have instructed lawyers to make those submissions, and some of whom are present in this courtroom. But the rule of law dictates that is not a relevant issue when we're dealing with the legitimacy of the 2013 Constitution.
Well, on the rule as you formulated, efficacy is the exhaustive test, and the answer is binary, yes or no. Is that right?
It is, Your Honour. It is. And Your Honour, can I just return to the facts in this present case, noting, of course, and Your Honours will see this in the transcript, very helpful concessions made by my learned friend on a whole host of topics. And I want to pick up a point, I think it may have been the learned president, I think your lordship may have raised this issue. There have been 3 elections in 2014, 2018 and 2022 And Your Honours will see this at paragraphs 130 to 133 of the Statement of Constitution Facts at tab 32 of the Court Book, pages 2201 to 2202. There have been 3 elections where the overall turnout has been 84.6%, 71.9% and 68.3%. That shows that the majority of the people of Fiji are participating in the political process established by the 2013 Constitution. Secondly, there have been 3 parliaments under the 2013 Constitution, which has passed to date 403 acts. We've provided you with a table in our written submissions, Table A, in the Court Book at tab 24, pages 1214 to 1215. Those are the laws, of course, the official laws of Fiji. There has been undoubtedly a formidable body of legislation. Thirdly, there have now been 3 presidents who were appointed under Section 84 of the 2013 Constitution instead of the Great Council of Chiefs as required by the 1997 Constitution. Fourth, when the President was absent from Fiji in September 2023, my Lord, the Chief Justice, acting under Section 88 of the 2013 Constitution, assumed the duties and responsibilities of the President and Head of State. That would not have been permissible under the 1997 Constitution if it remained in place, because that responsibility fell to the Vice President. Next, it can be taken on judicial notice that the courts have been effectively administered and judicial appointments have been made under the 2013 Constitution. And as I said, each of my lords and my lady took oaths and affirmations as prescribed by the 2013 Constitution and in the presence of the President. The courts have interpreted and applied the 2013 Constitution. That is evident from last year's Cabinet reference. Fifth, there's been recognition of the new legal order and government by the international community. We've dealt with this in our outline, but as late as last week, the Pacific Islands Forum of Foreign Ministers met in Fiji, hosted by the Government of Fiji. Sixth, it can be noticed that the current government is administering the police, defence forces and the public service. All governmental institutions are following the 2013 Constitution. Indeed, the Public Service Disciplinary Tribunal was one of the bodies established by Section 120, subsection 1 of the 2013 Constitution. Seventh, there is no suggestion that there is a rival President, Prime Minister or government that is ready to assume power. Now, the only evidence to the contrary is the evidence from the 2 affidavits of the Unity Party at tabs 29 and tab 30 of the Court Book, which relate to isolated incidences. But as we know...
There's some time ago too, aren't
they? They are, Your Honour. And as Prasad tells us in page 39, of course, what the court has got to do is look to the facts as a whole, not isolated facts. It's the totality of the circumstances that you have to anxiously scrutinise and not allow the isolated facts to become prescriptive. So in our submission, on the evidence as a whole viewed today, it is clear that the new legal order established by the 2013 Constitution is firmly and smoothly operating across the length and breadth of Fiji, and it meets the high threshold for the test of efficacy. And it is our submission that there is no doubt that the Constitution is valid and operative. And as I said, the state, quite properly through Senior Counsel for State, made those concessions. Your Honours, just before I turn to the third issue, which is, I think, really the heartland of the debate in this case, which is the proper interpretation and true effect of Chapter 11, our third issue on the outline of argument, I just wanted to briefly deal with the Cyprus case that my learned friend, Mr Walker, referred to, teasingly somewhat, on the question of what this court could do by use of the doctrine of necessity. Just want to remind the court, of course, that in respect of the Cyprus case, which is the Attorney General of the Republic versus Mustafa Ibrahim and others, 1964 Cyprus Law Reports 195, which is in the list of the amicus's authorities in the court book and appears elsewhere, our list of authorities. The Cyprus case was delivered during a time of warlike emergency, upheaval and rebellion. It dealt about the necessity of ensuring the due administration of justice the Cyprus constitution was actually unamendable. Cyprus was disintegrating as a country. Fiji is not. The present case, of course, apart from being distinguishable for all those reasons, is also distinguishable because the case concerned the invalidity of a statute. Necessity was not deployed to rewrite the constitution. And just that it's rather bizarre that this case would be somehow being deployed as the way to get home the state on giving you the pen to rewrite the constitution of the Fijian constitution. Can I just ask that Your Honours just note, I don't want to take you to it, but I just want to give you the reference. It's paid, well, it's actually helpfully not the page that I've got, but Your Honours will get this from the decision of Justice Vassilides. Having considered the jurisprudence and authoritative writings of other countries, to which this court has been referred as well as some others, I'm of the opinion the doctrine of necessity in public law is in reality the acceptance of necessity as a source of authority for acting in a manner not regulated by law, but required in prevailing circumstances by supreme public interest for the salvation of the state and its people. It's page 230 to 231 of that report. And the reason I touch upon that, my lords and my lady, is that on this question of what is meant to be the pressing urgency or the necessity for this, not a word has been said by counsel for the state, and was very skillfully alluded to by counsel for the Labor Party. Not a word has been said by the state as to what is it in the Constitution they want to amend. At page 11 of the transcript yesterday, I think it was Justice Arnold who questioned, it might have been Justice Young, who questioned my learned friend Mr Walker, well, will the immunities go if this reverts to being able to be amended like any other piece of legislation? And my friend, after a number of questions, ultimately accepted that proposition. But that's not why they're here. Well, they haven't said that. But what is it in this Constitution that is so in need of repair or amendment that the Parliament takes the view after just one vote and losing by one vote that they need to rush to this court, more or less trip over themselves to get here, to say it's impossible, you need to rewrite it. What do they want to change in the Constitution they haven't told you? Now, I am not imputing bad motive to the state, not at all. But one's got to look at the consequences of what you do when you propose an amendment like this. It may not be your government, it may be a successor government that uses it for bad reasons, to in effect obliterate the provisions in Chapter 2. It may deal with taking away jurisdiction from this court. We don't know. But the issue is, it cannot be reduced, as Justice Young said, directly and fairly to counsel. You're basically wanting us to reduce this so it can be amended like any other piece of legislation. And that's what they're doing. Can I deal with the third issue of our oral argument outline? To determine the issue about validity of the impugned provisions, the court must first interpret and characterise those provisions. And there are two contentions about the legal operation of Chapter 11. The first goes to the proper interpretation of the supermajority provisions. The better meaning in amicus's principal submissions should be accepted based on a contextual reading of the Constitution as a whole, and he will, more eloquently than I, defend his position. The starting point, of course, for decisions in Parliament is Section 69, subsection 1. This supplies the default rule that any question proposed for decision in Parliament must meet two criteria: a threshold, which is a majority vote, and two, from a base of the members present and voting, except otherwise provided in this Constitution. Section 162, subsection B, that's at page 101 of the Constitution, provides for a different threshold, that being at least 3/4. The language of the members of Parliament in section 160, subsection 2B, does not stipulate the base. It does not say whether it is of the members present and voting or all of the members. The better view is when we read the instrument as a whole, it picks up the base from section 69, subsection 1. Now,
Can I just interrupt there?
yes, Justice Arnold.
The Constitution provides that a bill can't be voted upon unless more than half the members are present. So on the present and voting approach, there'd have to be,
A quorum.
to comply with that rule, you need a quorum, which is 28.
Yes, Your Honour.
And three-quarters of that is 21. So it may be an extreme example,
Yes.
and you've still got the 30-day gap and the
Yes, sir.
standing committee to go through.
Yes, Your Honour.
But the present and voting approach does open the possibility of votes by much smaller majorities within Parliament.
Yes. I accept that proposition. Yes.
And all previous constitutions did refer to the supermajorities by reference to all members.
The previous iterations?
Yes.
I think they did, Your Honour, but I'll check that.
Which may suggest a literal meaning. But the truth is, this isn't actually the most awkward aspect of the case,
No,
is it?
it's not, Your Honour. Your Honours, for decisions at referendum, can I just note this? Section 160, subsection 3 requires the Electoral Commission to conduct a referendum for all registered voters in Fiji to vote on the bill. It is section 160, subsection 6 that then gives the threshold for passage. 3/4 of the total number of the registered voters have voted in favour of the bill. The state, of course, in their submissions at paragraph 9, I don't need to take you to it, it's at page 837 of the court book, says that the reading these two subsections together make it plain and unambiguous that an absolute supermajority is required. But that is not correct. Section 160, subsection 3 tells us who is eligible to vote. It defines the electorate for the referendum. But not every eligible voter casts a vote. We know that from the elections. A very significant and historical contextual fact is that the 1997 Constitution mandated compulsory voting. The 2013 Constitution does not. The total number of the registered voters should sensibly be read as referring to the registered voters who have voted. That better accords with the value of democracy, which envisages the people actively participating, if they so choose, in government and shaping their destiny by having the right to alter the Constitution by casting a vote. Your Honours, the second issue is the proper interpretation of section 159, subsection 2C, which goes to the power to amend Chapter 11 itself. Can I trouble Your Honour, can I trouble my lords and my lady to go to the Constitution at page 101 and look to section 159, subsection 2. One would immediately notice that paragraphs A and B are about Chapter 10 and Part D of Chapter 12. Paragraph C is about Chapter 11. Each of these paragraphs start with the same language of repeal, infringe or diminish. But importantly, where they differ are the words that follow. Paragraphs A and B go to any provision of the relevant chapter and part. In contrast, paragraph C goes to the effect of this chapter. That difference is significant. The question, and this is, I think, Your Honours, with respect, the critical question, what is the effect of Chapter 11? And one has got to look at, of course, the textual difference in the subsections and, of course, the purpose of Chapter 11. Now, this is what we say, Your Honours, is the true effect of Chapter 11 when confronted with the words in section 159, subsection 2C, that prohibit the diminishing of the effect of Chapter 11. First, the effect of it is to mandate that the process to amend the Constitution must be democratic. Presently, it is both through a process of representative democracy and direct democracy. But we accept that if section 160 is amended via a vote of the Parliament, and then, of course, the people in a referendum, it can be altered, if the people so choose, to one of those processes or both of those processes as altered. Second, it must maintain the Constitution as the supreme law, unable to be amended, like other pieces of legislation, by a simple majority, as the Constitution otherwise provides for in other chapters. If such a proposal was put to the people and it passed the two hurdles in section 160, then that could validly alter the Constitution so that it could be amended in that way. But it's critical when looking at the true effect of Chapter 11, which is what the controlling words tell us in 159 subsection 2C. It's got to have two elements. The true effect, mandate the process to amend the Constitution as democratic, and second, the Constitution is the supreme law. Any other method is invalid. Now, Your Honours, withdraw that. My Lords and my Lady, can I then deal with, if I may, the question of the amendment bill, just very briefly, of course, which is at page 2797 of the court book. As I've informed the court, this bill, of course, in effect puts forward a 2/3 proposition in order for the Constitution to be amended by the Parliament alone and not with the participation of the people of Fiji. As I said, it transforms, in effect, Your Honours, the power of the Parliament to make it, in effect, the supreme body to alter the Constitution without the involvement of the people. It changes the very fabric of what the Constitution presently is. And the bill doesn't shy away from that. But this was meant to be a bill on the way to going to the people. When they couldn't get the one vote, they re-pivoted and said it was impossible and have come here to get the court, in effect, we say respectfully, to provide it with the ability to do what is unlawful. Can I deal with issue 4 in the outline of the oral argument, which is the validity and constitutionality of Chapter 11 and Part D of Chapter 12? This now has me moving on to the issues about whether the impugned provisions are valid. This is where I deal with the second question in the court's memorandum of the 14th of August, which is, can the court recognise the 2013 Constitution as legally effective, qualifying its recognition of the amendment provisions so as to effect a reading down of those provisions? That is a variant of the questions that have been sharpened somewhat and circulated today. The question about whether the 2013 Constitution should be recognised as legally effective is separate to the question about whether the amendment provisions are valid or should be read down. The former question is dealt with by the test of efficacy under the common law, which I've addressed you on. The latter question is dealt with by what the state describes as judicial review of constitutional provisions, which is based on judicial interpretation of the Constitution and adjudication of its application. You'll find that nugget at paragraph 19 of their written submissions, tab 15 of the court book at page 808, page 844 of the court book. Now, this form of judicial review, according to the state, accepts that the impugned provisions form part of the text of the Constitution. I just want to develop our arguments on why there's no power to judicially review the Constitution once it's recognised as legally effective.
I'm sorry, before you do that, the question really addresses, doesn't it, the correctness of the answer you gave me earlier, namely affirmative to efficacy is exhaustive and there's only a binary answer in the common law recognition process. So the question which you're now addressing asks whether the answer doesn't have to be binary, it can be qualified. This is still, of course, outside the framework of the 2013 Constitution. It's looking at it from a common law lens.
That is correct, Ron. That is correct. And Our first submission is that no such judicial review...
Mr. Moses,
I'm sorry, Chief Justice.
I can see from the time that your time is up.
I think that's been the story of my
since
life,
you're-
Your Honour.
Since you're
My Chief
giving
Justice, yes.
interesting submission, I think I'll give you another 5 minutes.
I'm indebted to you, Chief Justice.
I'm looking forward to the answer to my question, Mr. Moses.
I could sit down now, my Lord. Our first submission, of course, is that no judicial review jurisdiction exists in the law of Fiji. The state submits that their submissions don't depend on the existence of a basic features doctrine, but does rely on it. You'll see that at paragraph 17 of their submission. The doctrine, in a nutshell...
Your Honour, the Chief Justice, can I just interrupt? I'm so sorry. I've just been looking ahead to the written submissions that have been, the outline prepared by my friend, Mr. Moses,
Yes.
and I am looking at the clock.
Yes.
And if Mr. Moses is going to get a reasonable opportunity, because he won't be back tomorrow, to address the additional issues, it seems to me one ought to give him the time that is necessary to fully address the issues, because I think the issue that Your Honour, Justice French is putting to my friend is a very important one, and I agree with the proposition from His Lordship Justice Young that there's not necessarily an authority that goes one way or the other. So I'd hate to feel that somebody who's not going to be heard tomorrow gets cramped in the presentation of his submissions. And I'm also just conscious of my own time and would not wish myself likewise to get cramped in the terms of making my submission. So can I just make that intervention, because I'm just concerned.
So you want to start tomorrow?
Well, I'm beginning to think that probably makes the most sense for me to start tomorrow.
Let's finish with Mr. Moses.
Okay, then we'll grant Mr. Moses further time.
I just think that's sensible in the context of the level of engagement that Mr. Moses has had with the bench, and bearing in mind that my role, to be said explicitly, is I'm not a partisan. I'm just here to assist the court, and therefore the nature of the engagement with me, I suspect, will be quite different.
Okay, then we'll permit you
tomorrow.
I can see from my colleagues, they agree for you to start tomorrow,
Thank you.
and we'll give the rest of the day to Mr. Moses.
Dinaka.
Just another 10 minutes, not the rest of the day.
A big
Yes, thank you, my Lord. Thank you. I'm indebted to President. So,
another 10 minutes, is it?
yes, Chief Justice. Now, as I said, the state submits that their submissions do not depend on the existence of a basic features doctrine, but they do rely on it. That doctrine, as Your Honours well know, in a nutshell, is that courts can judicially review a constitutional amendment and hold it to be invalid on the basis that the amendment is incompatible with the basic features of the original constitution. And the amicus explains this in his submissions. I'll give you the reference to it at paragraphs 82 to 84 of his written submissions, which are at tab 14 of the court book at page 776. This doctrine, assuming that it forms part of the law of Fiji, cannot possibly apply to the impugned provisions because they are simply not constitutional amendments. Both Chapter 11 and Part D of Chapter 12 are original provisions of a new constitution, and our friends for the state overlook that in putting that proposition. There is separately the unconstitutional constitution doctrine, where original provisions of a constitution can be unconstitutional under that constitution. The amicus deals with this in his written submissions at paragraphs 87 to 90, which are at pages 779 to 780 of the court book, tab 14. Now, the amicus submits that this theory has gained some purchase, but acknowledges that it is not uncontroversial. Both the authorities cited by the amicus from Honduras and Bangladesh are distinguishable in the instant case. Now, because the state and the interveners do not rely on the unconstitutional constitution doctrine, I just want to give Your Honours the reference to our written submissions as to why that doctrine is not applicable in the law of Fiji. You'll find it at paragraph 5.16 of our written submissions at pages 1229 to 1230 of the Court Book, tab 24. And I just want to make the note in respect of the Supreme Court of Honduras, it relied on the supremacy of international law to invalidate presidential term limits, which of course is entirely incompatible with the system of dualism in Fiji and other common law countries such as Australia, New Zealand and the United Kingdom. Our second submission, my lords and my lady, is about deriving the values, spirit, purpose and objects of the Constitution. And the Chief Justice at one of the earlier interlocutory hearings raised this issue. Some of these values and principles are expressly stated in the preamble, section 1 and in other parts of the Constitution. Others are derived by implication, as this court did in the Cabinet reference from last year that Justice Arnold and Justice Young sat on, which I'll come to, which is the decision number 2024 FJSC 3. But in deriving what the values and principles are, the courts look to the text of the Constitution as a whole. The text, of course, is not the only place they look. They consider drafting history, informed commentaries, societal character and surrounding context. But a value or principle, no matter how noble, can hardly be said to be a value or principle of the Constitution if it's not rooted in the text or if it is inconsistent with the text. There must be a fulcrum in the text of the Constitution. There is no contest that democracy, popular sovereignty and self-determination are at a high level of generality, values and principles that find support in the text of the Constitution. And of course in the brave history of the Fijians. But I submit that it is impermissible form of reasoning to derive a value or principle from the text and surrounding circumstances and then use that value or principle to defeat the text or some of it. And that is with respect what the state is asking the court to do. It is asking you to derive a principle of sovereignty from the text and history, elevate it to some higher, more superior principle, and use it to cut down or invalidate the impugned provisions by taking the people out of the role of amending the Constitution. That really is a self-eating proposition that our friends have put, very skillfully put by senior counsel for the state, but it is wrong.
But that would be valid if the Constitution was the result of the public being widely consulted. Your proposition would be valid. One would argue that it is not valid when the Constitution is imposed by a few.
And
do you get me?
And Chief Justice, you raise a very good point. And what I respectfully say, Chief Justice, is that what we know and the submission we put to the court for its consideration is that once you apply the doctrine of efficacy to this Constitution and it is determined to be valid, then that basically means that that consideration no longer is relevant to the determination of how you construe the legislation. That's our proposition. And Chief Justice, you've raised a very important point, but with respect, the law constrains how that is to be taken into account when we come to construe these provisions from the invalidity perspective. And our submission is that there is no authority that does that. None of the cases, not one, have ever used the interpretive principle in Section 3, subsection 1, or its equivalent in predecessor constitutions in this manner. It doesn't support that approach. What Section 3, subsection 1 requires is that a person interpreting or applying the Constitution to promote the spirit, purpose and objects of the Constitution and the values that underlie a democratic society. But the ultimate task that this occurs is when interpreting or applying the text. And this is where I just want to raise, if I can, the reasoning of Justice Arnold and Justice Young with, of course, the other member of the court in the 2024 decision. Can I ask that Your Honours take that up? It's at tab 2.3 of our authorities. And it's paragraph 86 at page 30, where Your Honours said this: because proportionality is one of the values underlying the Bill of Rights in Fijian society, the court must seek to promote it, or put another way, to avoid disproportionality to the extent possible. And then at paragraph 88, the second sentence, it is arguable that both meanings result in disproportionate outcomes, in the sense that both will disqualify from judicial appointment people who might meet the section 105 subsection 1 standard, but of the two, the second is less disproportionate than the first. Complying with section 3 subsection 1 requires that we choose the second meaning if at all possible. Those passages demonstrate, if I may say so respectfully, an orthodox application of construction principles, and demonstrate that section 3 subsection 1 operates like the principle of legality. Where the test is ambiguous or elicits two possible meanings, an interpretation that better promotes the spirit, purpose, objects and values are to be preferred. But it doesn't elevate the spirit, purpose, objects and values to override the text of the Constitution. And I'll just give Your Honours, my Lords and my Lady, the reference to this. It's in our authorities list in the cases to be referred to but not read. It's 3.16 of the tab. On the list, it's the decision of the High Court of Australia in South Eastern Drainage Board versus the Savings Bank of South Australia, which is volume 62 of the Commonwealth Law Report, 603 at 626. And it's just the very wise reasoning of Justice Dixon, where in the context of statutory construction issues, His Honour said this: notionally, to write the earlier provision into the latter may be a useful way of testing the consistency of the two provisions. But in its application, it must be remembered that when two apparently inconsistent provisions occur in one act, to reconcile them by interpretation is the only course open. They cannot both receive their full meaning as it's expressed. In other words, no one can say that two provisions cannot live together when the legislature which gave them life found room for them in the one enactment. So one cannot deploy section 3 subsection 1 to in effect ignore a chapter of the Constitution. That has no underpinning in any legal principle.
Right, can I just ask you a question before we run out of time that relates to this issue? And if I can just set the scene by saying that on my current thinking is that on the Prasad criteria, the 2013 Constitution should be recognised as having superseded the 1997 Constitution. And as you'll have gathered, the more difficult issue for me is whether that recognition can be withheld in relation to a particular provision.
Yes.
Now, I just want to remind you of Madzima Veiuto. Now, Lord Reid accepted as correctly decided, although he thought not necessarily for the right reasons, early cases from Uganda and Pakistan which upheld the jury validity of the actions of usurping governments. Lord Pearce differently accepted that the actions of the Rhodesian government would have some validity, but subject to limitations. Now, as it turned out, he would have accorded them a lot of validity because he would have upheld the detention of Mr. Madzima Veiuto. But he was envisaging that he would withhold recognition of some provisions or some actions. Now, they weren't talking the talk of the rule of recognition, but isn't it one view of the case that it proceeds implicitly on the basis that there can be different levels of recognition to the actions of a government which is calling the shots and running the show?
No, Your Honour. I mean, with all due respect, there's no such thing as an unconstitutional constitution.
No, I'm not talking about unconstitutional
No.
constitution. I mean, you're talking one set of words and I'm talking another. And
well, that's the problem, Your Honour,
Yes.
with respect, because what you're referring to with all due respect, cannot be applicable to what we're dealing with here in relation to this constitution.
Well, we are looking at the actions of a usurping government.
Well, it's not relevant, with all due respect.
Yes, but all right. Well, if you don't want to engage with
No,
it,
no,
that's fine.
I do, Your Honour.
Okay, well.
No, I do want to engage with you,
Yeah.
Your Honour. I just happen to
But you're
respectfully
cutting me
disagree
off,
with
you're
you.
cutting it off at the pass.
Well, I apologise. Well, I will stop.
All right. Well, they were actually dealing in Veiuto with what was a UDI constitution, although that wasn't fundamental to the case. There's a level of commonality between that case and this case, that in both cases the court has to deal with the actions of a usurping government. I don't know that those actions makes a huge amount of difference whether those actions are styled constitution or legislation or detention certificates. So at that level, and I agree it's a high level of generality, you have different tiers of recognition that are postulated by Lord Reid, really in passing I agree, and by Lord Pearce in more detail because he would decide the case on the basis of it. So Lord Pearce, who would accept that the Rhodesian government is in effective control of the country, and he would accord virtually all of its actions, as I can see, validity. But he would not necessarily accord validity to all their actions. Now, doesn't that suggest that there are tiers of recognition that are available to the court? It's not necessarily all or nothing.
And with respect, Your Honour, I would respectfully disagree and rely on the answer I gave to Justice French, which is, in essence, that efficacy overcomes the usurping.
But all right.
And when you come to...
So do you say that Lord Reid was right to say that he could withhold recognition of some acts even though they were of an efficacious government?
Well, that was dealing with the doctrine of necessity, Your Honour, was dealing through the prism of acts of the executive. What we're dealing with here is the doctrine of efficacy, which everybody, well, not everybody, I should withdraw that significant numbers of the parties have said and agree with the proposition that the doctrine of efficacy means that the 2013 Constitution is operative and valid. Once we accept that proposition, efficacy overcomes this issue that was dealt with in that decision, and it's not relevant then to deploy that to withhold recognition of a provision of Constitution. The court doesn't have the power to do it. There is no principle in that case or in any case that would permit that to be done. And I didn't mean it flippantly, Your Honour, Justice Young, and I apologise for talking across you, but there is no such thing then as an unconstitutional constitutional provision once we accept that efficacy has overcome the usurpation. So that's our proposition.
I mean, it's not always very helpful. In fact, it's hardly ever helpful to think of extreme examples. But you would say, no, whatever. Once one accepted the usurper's constitution was effective, every provision in it has to be accorded complete respect, even though. I put it that way, it is objectionable to the rule of law and breach of international law principles, contrary to the values of democratic society.
Well, it depends again, Your Honour, in terms of, Your Honour's said this is an extreme example.
Yeah.
It depends on what we're dealing with in terms of what international covenants one's referring to.
Well, all right. See, the ICCPR talks about self-determination. It I think could be said that the 2013 Constitution was promulgated in circumstances that were not in conformity with that. Complicating that is Fiji was not then a party to it. But it is now, and Article 1.3 imposes an obligation on the state, which I think extends to us, to give effect to the principle of self-determination. So in terms of whether we recognise a provision in the Constitution, might we not say, crikey, if we recognise this provision, are we actually giving effect to the principles of self-determination?
Well, with respect, and this is a circular argument, Your Honour, but if I can deal with the facts in this case rather than the alternative facts, the facts here are what our friends are doing by the very nature of the bill is removing democracy through the self-determination of the people being involved in the process to amend the Constitution. So you've got to look to what this bill is proposed to do. It is to remove the people from the democratic process involved with amending the Constitution. There is nothing that can be said about that would warrant the court to take what is, with respect, a step that is untethered to any legal principle. And I won't need to address you on the fifth point of my oral argument about relief, because I've said what I want to say about that. I might just end by putting the simple proposition that Your Honours are being drawn into a controversy which you do not have jurisdiction to deal with. This is, in effect, a perversion of the judicial power, which this court will not sign up to on a proper application of the authorities. Those are our submissions.
Ultimately one is that, I mean, the bill that propelled the reference to this court is an accidental feature of which doesn't really impinge on the question we have to answer, which is the primary question of recognition, and that is a question applying a common law test. And we're talking about the common law of Fiji, and your proposition seems to suggest that the common law of Fiji is limited to the test of efficacy as an exhaustive test with a binary answer. Now, the question I would put to you just finally is, does it have to be? The common law of Fiji is the law that this court determines to be the common law of Fiji.
That is correct. That is correct. It is the law that this court determines. That is correct, Your Honour.
Yeah.
But we would say, what is the shape of that common law if it's not the test of efficacy as set out in Prasad? What else is it? And nobody has really addressed the court on what is this new principle that you are to develop as a six-member court to apply here in order to strike down this provision. What is the principle that they say they want you to develop in order to do this? Nothing has been said in any cogent way to facilitate that occurring. In fact, our friends have not said Prasad was wrongly decided. Nobody has said it should be read in a broad manner that should have had other features to it. You've received no assistance on that. And what is this court meant to do? The court is not meant to, in effect, engage in revisionism by saying, well, I don't like how the 2013 Constitution came into effect, even though it meets the test of efficacy, so I'm going to develop a new principle, undefined, in order to strike down one element of it that I'm not going to recognise, because I choose, as the court, not to recognise it, because that's a proportionate response to it was framed by a number of people.
Well, obviously you would have to define principled
Yes.
application.
Yes, Your Honour. Otherwise...
You don't just pull it out of the air.
No, well, otherwise this court becomes like an island where, in effect, principles applying to it are untethered to anything developed in the common law. And that develops then a shifting sands approach to how one deals with the framework of the Constitution. Those are our submissions, Your Honour. I apologise, Chief Justice, for taking well in excess of my time, and I thank you, Chief Justice, for your patience.
Thank you for your submission.
Thank you.
Thank you.
I'm happy to call it.
Has Your Honour Justice Young had enough of me?
No,
Okay.
it was very nice to have you here, Mr. Rice.
Okay, I think that's enough for us today. We'll adjourn tomorrow, and tomorrow we'll hear Dr. Butler, 9:30. Thank you.